welcoming you to our continuing program of webinars, informational webinars for physicians and physician clients and advisors. And I'm very, very pleased tonight to have Jeff Goodis speak for us. Jeff is the preeminent malpractice defense lawyer, at least for physicians in Pinellas County, and has represented dozens of our clients at the expense of malpractice insurance carriers in a great many malpractice suits. And one thing I want to say from the outset here is, if you're listening, you may be in the middle of defending a malpractice suit, or you may be very concerned about a malpractice suit. But one thing I can tell you from 27 years of experience in this area is that they all eventually end. And when they are over, they are truly over, some sooner rather than later, but many of them thanks to Jeff's good work and advice. So Jeff, I thought I would just go ahead and hand off to you here. You've got a beautiful PowerPoint presentation that we looked at before, and I'll just chime in every once in a while.
Thanks, Alan, and I appreciate the opportunity. I do have to express at the outset some concern over your definition of preeminent, but I will try to do my best to go over the points that I think are generally things to be concerned about when you think that a suit might be coming, and including in there what to do if a suit is already with you, or if a notice of intent has arrived, or you think one might arrive. And so we'll talk in general about litigation defense strategies and get started. I don't think that most physicians know when a patient is actually going to be a plaintiff, and so as a result, I think that some of this, of course, will be review. It seems like common sense to someone like me who defends medical negligence claims, but that doesn't necessarily mean that it's everyday practice for physicians, and I think part of what I'm suggesting is that it become more of a everyday practice. And so going into the background of the patient with a complete medical history is a very important thing. And as you look at this list under Roman numeral 1, one of the things to consider if you're looking at this seminar from a risk management standpoint, these are things you want to be sure to do. If you're looking at this seminar from the standpoint of you're afraid you might be getting a claim, this could be a checklist. And if you're already in a claim, these are things that, if they were done, could be used to your advantage, and be sure that your counsel, whoever has been retained by your insurance carrier, is aware of these things. So first, obviously a complete medical history. Second, if there are records that are relevant to your care, were they requested? Were they reviewed? Does your chart reflect that they were? More and more these days, insurance carriers have arbitration programs. I think the carriers are very savvy relative to the advantages of arbitration programs and the disadvantages of them. It's something that as you go into coverage renewal, you should be talking to your carrier about.
So, Jeff, are you in favor of arbitration clauses, making patients sign a clause that they would have to go to arbitration as opposed to suing in court?
I think often, Alan, it depends on the nature of the practice. So in practices that have potential high risk, or multiple claim risk, OBGYN, neurosurgery, those types of things, I think that the arbitration agreements are potentially very useful. The carriers are especially attracted to them in multi-specialty practices and in multi-doctor practices where there are a number of insureds under the policy. And they are useful because they lessen the process, they provide an ability to pick your judges. And so, for example, there's a large group in the Tampa Bay area that uses arbitration clauses, arbitration agreements, and they're just beginning the process of arbitrating under those agreements and are selecting other physicians as their arbitrators. And that provides an advantage because that gives the physician that blue ribbon panel that we all wish we could have. And so there are definite positives to the use of arbitration agreements. The negatives are that, oftentimes the coverage is limited in a way. In other words, if you have a standard 250 policy, you lose control of the potential of, not lose control, but there's a potential for an arbitration judgment, just like there's a potential for a jury verdict in excess of that policy limit. So as we go back to the outline then, one of the things that I think that physicians unfortunately seem to me to ignore are those red flags. A patient begins to complain. A patient is bringing things into the office from the web and saying, I'm not sure this is being done right, and those types of things. And yet there's no reflection in the chart relative to discussions with the patient about potentially it's time for you to find a different doctor. And ending the doctor-patient relationship isn't easy, but it's doable, especially with the help of someone with experience on the legal side of it. That having been said, I meet with a number of physicians who find themselves in malpractice cases, and they say to me, I knew from the beginning this woman was going to be trouble. And my obvious question is, well, why didn't you suggest to her to find somebody else? And because it's difficult, and because you're busy, and because that's the reality of medical practice, you don't want to abandon a patient, etc. But if you're getting red flags, call someone and say, how do I deal with this in a way that puts me in a better spot? And then I think that we need to talk about this, which to me, and Alan, you and I have discussed this a number of times, people don't like to sue people they like. And from my standpoint, risk management-wise, the very best thing you can do to protect yourself is to have your patients like you. And that means building a rapport with them. What have you done to be sure that this patient likes you? What is your staff doing to be sure that they like coming to your office, even though it's a doctor's office, even though they have those issues? And those are the types of things that the physician can control. I remember years ago I went to meet with a new physician, a primary care provider who under managed care had literally thousands of patients, and I rang the bell outside the frosted window, and the woman immediately slid the file back and handed me a clipboard and said, fill this out, and she slammed the thing shut. Behind her on the wall was thousands of files, and she didn't bother to ask me who I was, why I was there, so on and so forth. And when we got to the nuts and bolts of the claim of the plaintiff against this physician, it was mostly because she had been treated so poorly and at one point had been told that the doctor was out riding, meaning that he was riding his horse, and that's why people were waiting in the waiting room. Jeez. You're not going to do anything in that situation except anger the patient, and that's going to be a patient who's looking for a reason to sue rather than looking for a reason not to sue. That's why I say here your office staff and waiting room are your first line of defense, and your attitude and attention to detail are next in line. Doctors who are responsive, who are caring, who even go out into the waiting room on a day where you're a surgeon, for example, and you've been called into a trauma, or you've been called away for a consult at the hospital, and you come back to the office and people are waiting. You go out personally and say, hey, I'm sorry y'all had to wait, and we're happy to reschedule. And I know that's not logistically an easy thing, but that type of rapport is something that will really, I think, help you. These again are probably knowns, but you'd be surprised at how often I get charts that are not just incomplete, but lacking in even the most reasonable detail. And those are things that have to be done. And I'd make an aside here for physicians who, especially physicians who attend to patients in the hospital. Time your notes. It is such an important thing for us to be able to recreate what happened. And notes that are not timed can often be, you can figure things out, but it would be easier and your credibility built stronger if your notes were timed. And I'd say probably the majority, not probably, definitely the majority of hospital chart notes by physicians are not timed, and that's important, especially in the day and age of captive carriers with hospitals where, you know, the question is the same people are controlling the claims by the hospital or against the hospital and the physician, and you know, you need to be able to support your position in that particular instance. Informed consent needs to be documented. More and more these days, I think a number of specialty groups are suggesting that informed consent has to be a written process. I don't think that's standard of care, but I think we're headed that way. And so a note relative to it is, of course, the bare minimum. And I'd suggest that you go and look. You can usually tell online if your subspecialty group has approved forms for informed consent. They're obviously done as a result of a lot of hard work by a lot of very intelligent people. And I suggest to my clients, especially in high-risk specialties, that they have a form that's been approved by their specialty group. And the key word in this particular slide is loyal. If you're having informed consents witnessed by someone who is just, you know, the latest medical assistant to come through the door, that's a potential serious mistake, because those people have no loyalty. They may be in the wind, they may be in another state. Who knows where they are when it's time for that to be something that is testified about. And so a long-time, loyal employee are the types of people that you want. I had a deposition a couple of weeks ago, and interestingly, and pardon my language, this was a long-time assistant in a medical group, and she said that she had gotten fired because she called the doctor an asshole. But she was there nonetheless supporting the physician because she thought he was a good doctor. The reality was she had worked for him for a very long time. There was a merger, those types of things. But that type of loyalty, you can't buy that anywhere else, and you might need it at some point. So documentation, again, more general documentation about reminders, sending the patient letters if they don't come in. Cases where patients are lost to follow-up are not atypical, and they're something that you can save yourself a lot of hassle with by sending letters that saying, we've tried to reach you, we're writing you this letter to say that you need to come in and see us, that type of thing. And here, more and more these days, because of the way medicine, like law, like plumbing, you know, like everything else, is about specialists, if you're relying on someone, your chart note should reflect that you've spoken to someone or you've relied on that interpretation, because that's the type of thing where if you say it later, it's going to have less credibility. All right. I think we're oh, there we go. So what do we do when something bad happens? Because, you know, what we're in these days is that John Q. Public thinks to some large degree that a bad result must be someone's fault. And I'm preaching to the choir, I'm sure, as to the physicians who are in attendance and who are listening, because that's the reality of the perception of what you do. And I think, Alan, you coined the phrase bad result insurance carrier, because that's really what it's come down to. We all know that a bad result is not necessarily malpractice, but certainly those are arguments that are going to be made, especially by the people out there. So these are important things to do. You've got to prepare a narrative of the incident, what your thoughts were, what your concerns were, what the background was, because it's never going to be fresher in your mind than right then and there. And, you know, it's not unusual to see something 18 months or 22 months down the road where the physician has seen literally hundreds, if not thousands, of other patients and doesn't have a good recall for what happened. You got to do that. You got to keep it somewhere safe other than the chart. That's the last place you want it to be.
Can you label it as attorney-client privileged?
You can. It's in anticipation of litigation. You don't have to necessarily call a lawyer to get the advice to do that. If you're of the mindset that this, quote, bad result, close quote, may result in some litigation, then I'm telling you now as a lawyer, you should prepare a narrative. It's in anticipation of litigation. I think that cloaks it with the privilege that you want.
Great.
And it shouldn't be provided by to anyone other than those people who you trust, i.e. your lawyers. That's a big assumption maybe, but lawyers and the malpractice carrier. And then, Alan, I think you added this retain personal counsel, but I agree with it. Even though I think sometimes the carriers are not wild about the idea of personal counsel, they understand it. They understand the reason for personal counsel, and I think from a physician standpoint, I'm an attorney who is on the doctor's side, but I'm not retained by the physician. In most cases, the physician has not chosen me, the carrier has chosen me. I'm hopeful, just like I'm hopeful the physician is establishing a rapport with his or her patient, that I'm establishing a rapport with my client. But the reality is, if you have someone that you've known for a long time that's trusted, you should make that person, the Alan Gassmans of the world, aware of the claim. Make them aware of what's happening. Make them aware so that in the event that that there's later action, you're already dealing with it. And Alan, we've probably, I've lost count. It's got to be in the 10s or 20s of times where a physician who you represent has called you with a question concerning a bad result. You've got me on a conference call, even though I may not do work for their carrier, etc. We talk about generally without a representation agreement, without a situation in which I'm officially representing the physician, here's what the steps you might want to take right now. And
right.
Those are things that are invaluable later. So I'd suggest it. I mean, I know Alan's very available, and I try to be, as well. And I think most people who do what I do make.
Well, let me mention let's talk a little bit more about this, Jeff. The insurance carrier pays your fee and selects you, but your client is the doctor. Correct?
Absolutely, absolutely. And in my side of what we do, we call that the tripartite relationship. So if you can imagine a triangle with the three corners of the triangle, and I put the physician at the top of the triangle. I put the insurance carrier in one corner of the bottom corner, and myself in the other bottom corner. And imagine the lines going between all of us. The carrier has a responsibility to the doctor. The doctor and the lawyer, their line is back and forth because they're in communication. The lawyer has a responsibility to the carrier who has retained them to report what's happening, their opinions relative to liability, case value, defensibility, etc. But the carrier makes the ultimate decision, and their contract says so. But if the doctor tells me something that I think is potentially adverse to the doctor for coverage, for future insurability, those types of things, my relationship is with the physician. I am not in a situation where I am ethically able to or would share that with the carrier, because my client is the doctor. And so I think that's an important distinction that you make, Alan, and it's a realistic thing. And if for some reason a physician feels like their attorney is not honoring that attorney-client relationship, that's something that should be concerning to them. And the carriers, if anything, they really get that. They get that the lawyers that they retain, because I think that the insurance carriers, most of the carriers, if not all the carriers who write coverage in Florida, they really understand that they're retaining the lawyers that they retain for purposes of defending the physician, for representing the physician. And does that mean that we don't ever butt heads with the carrier? No. But the carriers I do work for, the major carriers in Florida, they get it, and they do what's right in that relationship. And when they stray, or when someone feels like they stray, that's where personal counsel can come in and try to right that ship. But usually, if that's
the carrier does the right thing for the doctor.
That's right. And if there's a straying, I put that oftentimes as much on the lawyer as I would the carrier. The carriers are, remember, getting their reports secondhand. That's coming through the lawyer, not directly from the lawyer, or not directly from the insured. Some of the carriers have started, which I think is a very good exercise, of including the physician in their discussions with the lawyer. And we'll get to a screen that discusses it. One of the biggest problems associated with defensive malpractice cases is not the relationship between the carrier and the doctor, or the relationship between the lawyer and the carrier, but the relationship between the lawyer and the doctor. because I had a meeting yesterday with a physician in Tampa who wanted nothing to do with me. But you know what? I'm his lawyer, and he looked at me as another awful part of the system. And in reality, I understand I even empathize with his concern. But the reality is, I'm his best friend in the process. And physicians who want to meet me at 5:30 on Thursdays because that's when they meet lawyers, that's not going to work. If that's when they want to reserve for Depo times and that type of thing, that's fine. But this has got to be a team report, a team effort, and that I can't stress that enough. I'm going to kind of go.
I just want to mention, Jeff. Sometimes I spend very little time acting as personal counsel for doctors being sued. But sometimes if I just make a short call and introduce myself to a lawyer who's representing the doctor and paid by the carrier, that lawyer will sometimes say to me, off the record, I wish you would write me a letter insisting that I hire another expert, or insisting that I get a second opinion from the expert, or insisting that the carrier settle the case, because I'm a little bit bashful asking the carrier directly because they pay all my bills. So sometimes it's just helpful for that personal counsel to be there. We don't have to do much. Sometimes just being there makes the difference.
Yeah, and you know what? I'm sure that happens, and that's a good thing if it does happen, to the extent that a lawyer feels the need to involve personal counsel. My experience is better than that. In other words, I can't really remember a time when I'm not able to tell the carrier, this is what I think. I've not ever had a carrier tell me, don't retain an expert. Now, I've had a carrier say, we're not going to sell this claim. We think it's one that can be defended. And I've had very successful results with that and not so successful results with that. But in the situations where it was not successful, the carrier stood behind the physician and dealt with the aftermath. So I've had good experience, and I've had cases that were big losses and cases that were big wins at trial. The real key is that personal counsel helps to protect the physician, and that's the reason that you want personal counsel, because in this tripartite relationship, it's nice to have somebody who's outside the triangle from time to time. The things on the slide now are not things I think have to be discussed in depth. They should be common sense. These are things that are not not going to be helpful to any physician. But this is something that and Alan, you and I have talked about this. This is something that I can't stress enough for the physicians who are in attendance and those listening. You've had something happen with a patient. It's of concern to you. You fear the potential for future action. You've talked with your personal counsel, who maybe involves someone like me, and you've had general discussions. And 3 months or 6 months or 8 months or 12 months or a year or whatever down the road, someone asks for copies of the patient's records, asks for copies of the patient's chart. And I'm obviously generalizing and probably stereotyping, but I can tell you quite bluntly and honestly, when we get medical records from physicians, if I were to subpoena those medical records 5 times, just me, I'll get 5 different copies of that chart, likely. At least 3 out of 5 charts will not be, everything that's asked for on the subpoena. So now you've got the situation where you've got the concern that this is going to turn into something, and again, stereotyping and generalizing, so I apologize if this addresses a physician who does it differently, but you get this request and you hand it to the lowest paid person in the office and say, copy this chart. That is logical from the physician's perspective. There's a law firm management company that advocated years ago buying white baseball hats and writing on the front of the baseball hat the average cost or average profit of every employee in your office. And by that I mean if an attorney is earning, $400 an hour for the office, it's a plus sign and 400 on his hat. If a secretary is costing the office, $22 an hour, there's a minus sign and a 22 on her hat. And the idea is that if you see a lawyer standing at the copy machine making copies, that's not an effective use of that person's time. And I worked for a firm in Atlanta where one of the partners had obviously heard this theory in a seminar, and he was adamant about never getting up from his desk to do anything that wasn't billable. That does not hold true, in my opinion, in a situation with a physician being asked for medical records of a patient who may be contemplating a claim. This is an event which requires your personal attention. This is something that should be done. An exact copy should be made. It should be kept somewhere safe. So when your lawyer says, what did they get, you can say, this is what was sent to them. I can't tell you how many times I've seen allegations develop in a lawsuit of they didn't give us the full chart, they added pages to the chart, when it's not true, but it's the appearance. And so in my opinion, if I'm advising somebody on risk management, I tell my clients, look, before a chart goes out the door on a case that you have a concern about, a patient you have a concern about, that's something that you should review. And if necessary, you should call your lawyer and say, hey, what do you think of this? I have physicians who call me and say, hey, I just had a surgery. I think the patient's going to be fine. I'm concerned about the potential because of, a complication. I think it's a known risk and complication, whatever. Can I send you the operative report before it's finalized? I don't think there's anything wrong with that. And I think it's doable in most cases. Certainly different and more difficult if it's a hospital dictation system. Doesn't mean you can't write things out before you dictate them, before they go in. I'm not suggesting forgery. I'm not suggesting saying something that didn't happen. I'm not suggesting backdating or changing records. I'm just suggesting that this is an important event. I think it's also worth thinking about, and Alan, I know you've experienced this with some of your clients, where the lawyer calls and says, hey, I just want to talk to you about what happened with this patient. And it surprises me how many physicians will sit there and talk with a lawyer about what happened, including things that, we might have done this differently, or maybe the hospital could have done this better, before they ever talk to a lawyer about that. This is not the Miranda rights here. Anything you can't, you say can and probably will be used against you at some point in the future. I'm starting to think. I'm sorry, Alan.
I'm saying that's an absolute fact. We see that over and over.
Yeah, and I'm starting to feel like I'm saying repeatedly, just call your lawyer, but there's a reason why you guys develop develop a relationship with an attorney, or should develop a relationship with an attorney, because while certainly members of our profession can be your worst enemy, the fact is that many of us can be your best friend. And that just says better for the doctor's lawyer to talk with the plaintiff's lawyer rather than the doctor talking to the plaintiff's lawyer. There may be a situation where ultimately your talking to the lawyer makes sense because you've had that situation, felt out, explored, and it turns out they're really not after you. But I'm defending a physician right now whose deposition was given in a very contentious case, and he never asked anyone to look at the case, and now he's a defendant in it. And, he was misled, I think, relative to the situation, and checking that out with someone like me probably would have stopped that from happening. Many of the insurance carriers have what they call Depo cover, meaning that if you call them and say, hey, I'm being deposed, they'll pay as a courtesy to you as part of your policy to have someone like me come out, sit with you, review your chart, and prepare you for the deposition. That's a good thing. I think, Alan, we want to get past some of this and talk about what happens, more in the lawsuit. So because this is, online, you'll be able to look at this and hear things as they go. But this is some of the things that, that I think are important to do when you get that notice of intent, the 90-day notice of intent. And most carriers will work with you if you know someone, or your business and or estate planning lawyer has someone who they trust and know. If that lawyer is on the defense panel or someone who the carrier knows of, they're pretty reasonable about assigning someone that you're comfortable with, and making sure that your representation is what you need, what you think you need it to be.
You're right. Yeah, we find that oftentimes if clients will call the carrier and ask for a list of the lawyers on their panel, that the doctor can then pick a lawyer on the panel who we know is going to be responsive, and that lawyer is going to appreciate being chosen.
Absolutely. Go ahead, Alan.
We also know that a lot of times the carriers try to do the 90-day letter process without a lawyer on their own. And sometimes they don't do as good a job as an outside lawyer would do on the 90-day letter process.
Unfortunately, the 90-day, discovery process is not really what the legislature imagined it would be. I think a number of the carriers do that because they have a lot of experience in trying to determine or in determining what is going to be and what is not going to be a likely claim. I work for carriers, and so I guess I probably to some large degree sound like an advocate for the carrier. But the carriers are responsive at the very least. They have their opinions. They're thought-out opinions. I don't think they're knee-jerk opinions for the most part. And if their opinion is addressed by someone, and that's the point of talking to someone, if their opinions are addressed by someone, they will usually reconsider them if that's what's necessary. And so that's why this team approach, this give and take, if you abdicate complete control to the carrier and the lawyer for purposes of defending a lawsuit that you're in, you're making a mistake. And let me say it this way. Imagine a situation in which a lawyer who is suing you has retained an expert, someone who may or may not be a credible expert, but they've retained an expert, especially in a case that you think is without merit, and they've retained a questionable expert. In that situation, I can almost guarantee you that every time the plaintiff's lawyer wants to talk with that expert about the case, he's getting a significant charge. He's raising his costs. He may be, in some instances, reluctant to spend the money and therefore not be as educated. Now imagine the opposite of that. I get to call you, my client, anytime and say, here's what I'm seeing. Can I have your opinion on it? If you're ready, willing, and able to give me that, I have a built-in expert that I'm not having to pay for, that I'm not having to spend money on, that's readily available. And so what you'll find is the more readily available you are, the more readily available your defense lawyer will be. It's a symbiotic relationship, and I can't stress that enough because I have many clients who tell me, I'll talk to you when I can. What I'm telling you is you gotta make time. You gotta cooperate with your attorney, make yourself available. And I say you're on his time now. What it really should say is you're in his or her realm now. And I know there are a lot of very litigation-savvy physicians, but I think you need to be thinking about how you can interact with your lawyer in a way that makes things easier for you, which means making things easier for her or him. This slide is true, but a little morbid, but it is the way our industry works to some large degree. Oftentimes, you won't see a lot of progress in a case. That's not always of design, but sometimes it is. And if the patient's elderly, if the survivor's elderly, things may not be pushed significantly if the lawyer's not pushing things, because it may strategically be in the best interest of the physician to allow things to go. All right, now we're going to talk a little bit about discovery in the lawsuit itself. And for those of you who are in lawsuits, you're probably already in this. For those of you who are worried that you're going to be in it, I think describing it to you could hopefully be of some benefit to you. The long and short of it is that the rules of civil procedure allow for investigation of the facts and circumstances of any claim, with taking depositions, serving written questions known as interrogatories, and interviews of witnesses, etc. And this is a situation in which you want to really interact with your counsel in this process so that you have not only input but knowledge. Because if you rely on counsel to simply do everything, then when it's time for you to prepare for your deposition, for trial, or whatever, you'll be starting from scratch instead of starting from a position of knowledge. And I know that as a physician, you want to start from a position of knowledge because that's how you have to approach practice to be successful in it. And so, I think it's important that you discuss litigation plans, that you be aware of what's happening. I'm not suggesting that you should tell the lawyer how the case should be done. And many instances, I got to tell you, a doctor calls me and says, I think you should depose Dr. Smith. I saw him in the hospital, and he told me that he'd give favorable testimony. The problem is that Dr. Smith's records may be more valuable than Dr. Smith's comments, and oftentimes with a physician who's being deposed, strategically you may be facing a situation where opposing counsel can find a way to dig something out of that doctor that they wouldn't otherwise have. And so you need to give your ideas, you need to give your input, and then, in my impression, is you need to listen to the reasons why the lawyer thinks that's a good idea or not such a good idea. And like I said repeatedly and ad nauseum at this point, it's a it's a symbiotic relationship, and you have to be willing to talk about your skeletons so your lawyer can be prepared, to deal with them. Ultimately, then we get into the situation with the court where, as a defense lawyer, I'm trying to fine-tune the litigation. I'm trying to get things into a posture where I feel like this is going to be our best bet with the ability to defend the claim. And how do we do that? Through deciding questions of law with the court, by trying to stipulate to things that we can, trying to narrow the issues that a jury has to listen to. We may seek to dismiss some of the claims that we don't think are applicable, that are not supported by expert, opinion. Summary judgment is rare. The court rendering a decision that the doctor was not negligent or did not cause negligent injury is a rare occurrence in Florida. The Florida courts have said a scintilla of evidence that creates an issue of fact is enough to get past summary judgment. But there is an ability to narrow the issues, and you should be instrumental in that process. I think the point of the entry here, the appeal, is that unfortunately in our process, like in yours, when you're treating a patient, just because you got a positive reaction to a medication and that may be emblematic of diagnostic and therapeutic, it doesn't mean that the problem is over, and so follow-up may be necessary, and that may mean that there's a future to the litigation even after you think that it's complete. I think if there's a takeaway, and Alan, I'll certainly defer to you on the next number of slides, but I think if there's a takeaway from the things that we've been talking about here, it is that to some large degree, I advocate that my clients look at this to some large, to a major degree as a team approach. How can we together defend a claim that is meritless? How can we together discuss resolution of a claim that may have merit? How do we interact with the carrier in a way that protects the physician, protects their reputation, their assets, their practice, etc., and make points known that are important in a way that gets everybody, hopefully on the defense side, to the same page. And that's where the interaction between counsel and physician works. And Alan, I'll let you go to your.
I think before we go further, why don't we talk about the question of bad faith because I find, most physicians are very, very concerned that a claim could go over their policy limits. And while before they get sued, the typical mantra is just buy the least amount of insurance because otherwise you're just putting a bigger target in front of you, and don't get more than the minimum amount of insurance because if you do, they're more likely to sue you. And then once the lawsuit starts, then the doctor is thinking, oops, I wish I had more coverage because now this could go over policy limits.
It's an interesting problem. I get asked all the time, especially at the conclusion of a case,
right.
Should I up my limits? Should I lower them? I never have a really good answer for it because I don't think it's a malpractice decision. I think it's a business decision. And I think to some large degree, the decision relative to the amount of coverage is in direct relation to the amount of asset at risk. So I know a number of physicians who have 250 policies because they have someone like you, Alan, who has, very carefully and thoughtfully protected their assets with obviously not a guarantee, but a likelihood of protection in the event of a verdict in excess of the policy limit. I also have a number of physicians who have little or no downside risk for anyone accomplishing a taking of their personal assets, who have millions of dollars in coverage, who I suppose may be included in a loss or a claim because they have that coverage and they become a deep pocket. I'd like to think that plaintiffs' lawyers don't target coverage, but it's not true. There are a number of lawyers who target people because there is more coverage. They are willing to target a physician who may not have liability and or to make an effort to create liability for that physician because there's deeper pockets. And that's terrible, but it's true. And as much as I almost hate to defend that lawyer, there also may be on the other end of that equation a catastrophically injured child, for example, that they feel like they are helping by doing that, and they probably are helping them, even if it's not something that I think is something that hopefully I wouldn't do if I was on that side of the process. But I can almost understand it. That being said, the decision relative to how much coverage do I become a target or not is a direct response to the potential for downside risks associated with it, and then with it being an excess verdict. Of course, if you had a crystal ball and you wouldn't be in the malpractice case in the first place because you'd see the patient and then go into your office and look in the crystal ball and see what was going to happen and change the course if you could. So that's a difficult question. Addressing the issue of bad faith is a completely different situation, and it changed significantly with the change in the law as it relates to what we on my side of the business, i.e. someone who has relationships with insurance carriers, call the safe harbor provision. And now, pursuant to Florida statutes, if an insurance carrier tenders their policy limit, whatever it may be, $250,000, $1 million, $5 million, whatever the number is, within 210 days following service of the complaint on the defendant, that insurance company cannot be held responsible for bad faith in Florida. It doesn't mean that the lawyer for the plaintiff or the plaintiff has to accept the policy limits. It just means that it has to be tendered, meaning, in my opinion, to some large degree, the insurance carrier has to actually send a check for $250,000 to the plaintiff's lawyer on behalf of his client with a reasonable release and say, we would like to conclude this case, here's our money. If that happens, the carrier is protected by the change in the recent change in, well, it's actually been a number of years now, but the change in the law known as safe harbor. How does that affect you as a physician? This way. the carriers now have 210 days, 7 months basically, to investigate a claim. That far into a case, a plaintiff's lawyer may decide that he is not going to, that he's going to be precluded from pursuing the carrier. It does not mean that he would be precluded from pursuing the physician in the event of an excess verdict. And I think, although it's not yet been tested to my knowledge, I think it would mean that the physician is unable to pursue the carrier. In other words, there would be no first-party bad faith saying you should have protected me, because they shall not be held responsible for bad faith if the money's tendered in the first 210 days. All that means to me, from the perspective of litigation and the question of the potential for a verdict in excess of the policy limits, is that as an educated physician, you need to be saying to counsel early, have you valued this case? What is the potential for a verdict in excess of my policy limits? Should I be retaining personal counsel? And to me, when I meet with a physician for the first time, I suggest that the physician should retain personal counsel without regard to the merits of the claim. And it's not because I think the physician did anything wrong, or maybe the physician did do something wrong. Even before I'm into those details, I suggest that personal counsel is a good idea because of the intricacies concerning the relationship between the carrier and the carrier's decisions concerning whether a case should be defended or settled. And so as it relates to bad faith, there's a new wrinkle, that wrinkle being what is the carrier going to do in that first 210 days?
So 210 days from when the suit is filed, Jeff?
From when it is served.
Okay, so within 210 days before the suit is served, often the plaintiff lawyer will offer to settle within policy limits, hoping to do one of two things, to either get a check for $250,000 or to have set a hook against the carrier, so if the verdict comes in above policy limits, the carrier may be responsible. Right?
Yes.
Does that crystallize it?
But what happens for all intents and purposes is if the carrier waits past the 210 days, then they have a potential, then, I guess we're back to what we were talking about as it relates to the old style. In other words, if they wait more than 210 days, could they be on the hook for a verdict in excess of the policy limits? The answer is yes. But if the monies are tendered in the first 210 days, there's a potential, not a potential, the statute says that they shall not be held liable for bad faith. I'm actually
I see. Okay.
The beauty of doing a webinar is that I'm on the computer at the same time. The Florida statute is 766.1185, and it says an insurer shall not be held in bad faith for failure to pay its policy limits if it tenders its policy limits and meets other reasonable conditions of settlement by the earlier of either the 210th day after service of the complaint in the medical negligence action upon the insured. So,
okay.
And I mean, it goes on, and there are some other issues, but the reality is, I think to some large degree, if a carrier tenders their money in 210 days, even if it's not accepted, there's a strong likelihood that the carrier is not going to be the one on the hook for a verdict in excess of the policy limits. So as it relates to the potential for a verdict in excess of policy limits, what I'm saying is the takeaway is you need to really be aware as a physician of what's happening in the beginning of a claim. Because if your feeling is this is a bad claim, it's got real potential for serious damages, you need to make your voice known early. And that's part of the process of the interaction between counsel and client. So if I can't get a hold of you, if I can't, Alan, you and I are dealing with one right now where it's difficult to kind of get a hold of the physicians.
Right.
And in that situation, as you know, my file is full of my warnings to the client about the potential downsides. Not
but
because
Jeff, we only have a couple minutes here, but getting back to the bad faith, what I wanted to crystallize is the plaintiff makes an offer to settle within policy limits. The private counsel for the doctor writes a letter to the carrier saying, we think that you need to go ahead and settle this thing.
Right.
The carrier then decides whether they're either going to settle it or the risk is probably going to be on them if there's an excess verdict.
As long as they don't tender within the first 210
As long as they don't,
days.
right.
Yeah.
Right.
So if there's a, let's say that there's a demand, or the plaintiff does what we would call a setup. The plaintiff's lawyer sends a letter, says, pay me the policy limit. And the doctor contacts personal counsel sends a letter to the carrier, and it's 90 days into the claim, and the carrier says, no, we're going to continue to defend the matter for the time being. We want to further investigate it. And at the 209th day, the carrier offers to settle the claim, and the plaintiff or tenders a settlement, and the plaintiff says, no, you know what, we don't want it anymore. The carrier is going to be protected. If the carrier makes that decision on the 211th day, there's going to be the argument available that the carrier is responsible for the excess verdict. So what I'm saying is if the carrier makes that tender within the first 210 days, the argument that the carrier is responsible, even if the lawyer, personal counsel made demand, et cetera, it's not going to work. That argument's going to fail, and the carrier is going to be protected.
Okay.
Does that make sense?
Yes, it does.
Okay. So those are the comments that I had to make, Alan, and to the extent that you want to follow up or, reach some conclusions or questions or whatever, I'm happy to take your lead.
Yeah, we've got a couple questions here from the audience. I guess the first one is, how long does a malpractice suit normally take, and how much time does a doctor have to budget for having to endure one of these?
Endure is the right word. The Florida Supreme Court says that a malpractice case should be over 18 months after it is filed.
Wow.
That is the best case scenario. I think it would be very, very infrequent that a claim is actually concluded within, within that time period. I think more realistically, unless the claim is going to, be settled or whatever, more realistically, you are looking at, 24 to 36 months, start to finish. Now, that is not, by any stretch of the imagination, a situation in which the doctor will be contacted on a daily basis, or the doctor will be, in fact, there may be, months where not much, if anything, is happening in the claim. But if you set up a communication avenue with your counsel, and your counsel is doing, what I think they should do, they're going to be contacting you when they need your input, when they want you to know something. And if you get a letter from counsel, once a month or once every 6 weeks or 8 weeks, and there's nothing for you to say about it, don't say anything about it. Read it, be aware of it, put it in your confidential file, and move on. What I tell my clients is there's concern in medical negligence cases. As a physician, you should be concerned about having to be involved. But the worrying is supposed to be what I do for you. And so if you're worried, call the lawyer and tell them why. If you've got, issues with timing or whatever, call the lawyer and tell them why. But to the extent that you make yourself available, then the lawyer will make him or herself available, and that will be the successful relationship that you want. I think that for the most part, and I'm not 100% successful by any stretch of the imagination, but for the most part, my clients find that they get information, probably more than they need, because as Alan, as you know, I like to really kind of be sure my client is aware of what's happening. But it's going to be a process. Your availability will make that process easier, because frankly, I think if you're talking with that lawyer, it will also serve to comfort you frequently about things that you may have concern about that are really not something to be concerned about.
Right. I find when clients, really need to come see me and just got sued or finally want to talk about a lawsuit, and I hear them out, my first advice is often don't worry about it because it's going to settle, as so many of them do. And I think on the screen now we're showing number 6, not using appropriate worry and crisis management techniques, because I think a lot of us just over-worry about things that are never going to happen. And usually a jury trial doesn't happen and an excess verdict doesn't happen. What happens is a settlement. And I always tell a physician client when they're being sued, when this is all over, I want you to think back and think about whether you wasted a lot of time and energy worrying about this, because it's going to be over.
I think you're right to some large degree, and that is that the carriers are at the very least very educated on what they think is a likely reasonable settlement, what is a likely potential verdict, what is a likelihood of success at the time of trial in the defense of the claim if you decide you're going to try it. And so the carriers don't go in willy-nilly and say, we're going to try this case. Do they try cases and lose? Of course. But in those situations, I think it's very rare that they don't step up and handle the aftermath of that situation. It may be, there may be appeals. It may be very trying on the physician, but that process is going to be, the likelihood of a physician's assets being ultimately seized are very low. I mean, wouldn't you agree with that, Alan?
Yes.
Yeah.
It's like everybody who gets a bump on them and goes to the emergency room thinks they have cancer.
Right.
And the odds don't work that way, fortunately. It must feel the same way to be a physician being sued.
Yeah,
But most of these cases go away when the clients have good advice and they do the right things. So, and with that, I think our hour is over.
Okay.
Jeff, you did a great job as always. I want to thank you not only for doing this program with us tonight, but also for being available. And as wonderful as you are, taking care of people, seems to me 24/7, defending doctors, and I think probably about all you do is defend doctors.
Yeah, it's the 95% of my practice is representing physicians in medical negligence cases, and my father's an oral surgeon, so it comes naturally, and if people have questions, I got a call from Colorado recently. A guy called me who was interested in potentially coming to Florida, and he had heard about my name at a cocktail party from a physician from Florida and wondered if he could ask me some questions. I learn from the questions that get asked too. So to the extent that anybody has those questions, I'm happy to, when I can, answer them.
Right, and you can send an email. I've got the screen back on to Jeff at jmg@thompsongoodis.com if you have any questions, or he's reachable at 727-823-0540. And, of course, clients of mine all know that you could always contact me and how to contact me. But I want to thank you again, Jeff.